Get ready for the dictation. Start. The petitioner was appointed as lecturer in mathematics in the Institute of Engineering and Rural Technology, Allahabad on 6th September, 1983. Stop. The petitioner's wife, Dr. Sarita Srivastav, joined as lecturer in Sanskrit in the Rajshri Tandon Mahila Mahavidyalaya on 31st March, 1989. Stop. Both the petitioners were receiving house rent allowance from their respective institutions till January, 1996, when the house rent allowance of petitioner's wife was stopped by the principal on the ground that she is not entitled to receive the same since her husband is already receiving the house rent allowance. Stop. The petitioner gave in writing that the house rent allowance to the petitioner be not paid and the house rent allowance to the petitioner's wife be restored with effect from March, 1996. The house rent allowance of the petitioner was stopped and that of his wife was restored with effect from March, 1996. Stop. The petitioner submitted a representation on 17th February, 1997 to the Director, IERT, seeking payment of house rent allowance as well as arrears of house rent allowance on the strength of the division bench judgment of this court in the case of Dr. Maya Rani Srivastav versus Director, Higher Education, UP, Allahabad and others, AIR 1998 SC 157. Stop. The petitioner submitted reminders. Stop. The Director, IERT, by order dated 5th September, 1997, directed for payment of house rent allowance to the petitioner in pursuance of which the Joint Director, Technical Education, Varanasi, started payment of house rent allowance to the petitioner from October 1997. Stop. The petitioner thereafter submitted another representation for payment of arrears of house rent allowance from March, 1996 to September, 1997. Stop para. On such representation of the petitioner, the Director Technical Education wrote to the state government seeking appropriate direction for stopping the house rent allowance of the petitioner. Stop. In the reference letter dated 11th July, 2000 of the Director, Technical Education, it was stated that when husband and wife both are residing in the same city and in the same house, both are not entitled for house rent allowance, and the judgment of this court in Dr. Maya Rani's case (supra) cannot be applied in all matters. Stop. The state government wrote a letter on 21st October, 2000 to the Director, Technical Education, after receiving which letter, the Director, Technical Education issued an order dated 10th November, 2000 for stopping the payment of house rent allowance to the petitioner and for taking steps for recovery of irregularly paid house rent allowance to the petitioner and further to submit a report of responsible official in that regard. Stop. This writ petition has been filed by the petitioner challenging the aforesaid order. Stop. In the counter affidavit filed by the state, it was stated that in view of the clear policy of the state that if husband and wife both are in the government service, the house rent allowance is not payable to both of them, hence the order issued were perfectly in accordance with law and the petitioner was not entitled for payment of house rent allowance. Stop para. As has been recorded in the impugned judgment of the High Court, when the writ petition was taken up for admission on 14th May, 2010, the fact that the petitioners had withdrawn the condition with regard to the provision of foreign exchange rate variation, was considered, and it was also observed that such subsequent withdrawal could not affect the bid of the petitioner's stop. However, on the submission made on behalf of the petitioners that the aforesaid condition was also included in the RFP submitted by respondent number 4, notice was issued in the matter stop. Consequently, while taking up the writ petition for final disposal, the issues framed for deciding the writ petition were centered around the said question stop. In fact, the first issue, which was framed, was whether a bidder could amend its bid by withdrawing a condition of the bid document, whereby the bid was considered to be non-responsive stop. The second issue, which is an offshoot of the first issue, is whether a bidder would be entitled to contend that a non-responsive bid be treated as responsive since the offending condition was withdrawn after the bid documents had been opened stop. The third issue raised was with regard to the bid submitted by respondent number 4 and whether the same could be treated as responsive although the price offered by the said respondent contained a foreign exchange rate component which was to be considered at a particular rate stop.